enforcement. Mr. Tomas and myself were in my office yesterday to conduct depositions. He and I were having a conversation where I mentioned I'm likely going to be calling Detective Wilson in rebuttal if the defendant takes a stand. He says something to the effect that they were saying things to me, they were trying to push me and convince me to waive Miranda. So I got Detective Wilson's phone number, I reached out to her, and Mr. Tomas was actually in my office, and I confirmed her availability at that time. A few hours later, as I was preparing for today, I called Detective Wilson and asked her kind of what the process was of everything. And she's seen on that interview as well. Detective Wilson advised me that at a point in time, both her and Detective Janoris took the defendant to the bathroom. Her and Detective Janoris, because Detective Wilson was shadowing at this point. She was a domestic violence detective at that point, and she was shadowing both robbery and homicide to see if she wanted to go to either of those units. They're having a conversation about where Detective Wilson is, what she wants to do, etc. The defendant is in the bathroom stall at this point in time, comes out, washes her hands, and goes to Detective Wilson. It says something to the effect, I don't remember she doesn't even remember the exact words, but she says, oh, you're a domestic violence detective, starts inquiring about that, and then says, I'm a victim of domestic violence. Detective Wilson at that point in time puts her hands up, motions to Detective Janoris, and says, you need to tell them, not me, you need to speak your truth to them. The best I can surmise based off of the timeline and everything else, and also her deposition yesterday, which was taken. This is prior to even the first Miranda being read, in which the defendant invokes. I turned that over to Mr. Tomas yesterday, probably around 2 o'clock, I think, and then we ended up taking Detective Wilson's deposition around 3:30 yesterday.
Okay. Well, what's the ask for the Richardson?
Because I turned over a defense statement.
Oh, I'm sorry. You're saying
I violated.
You turned over late.
Correct.
Okay.
Yes.
All right. Do you want to respond? He's saying it's late when he found out. It sounds like he found out about it yesterday and turned it over upon finding out about it.
Yes, Your Honor.
So the issue is willful inadvertence. Will you prejudice in any way at this stage? What the state is saying is this domestic violence detective came in contact with this link even before the statement was turned over. So her identity.
Yeah, it's fine. I'm not necessarily seeking to exclude her at this point.
Okay, so we've done the Richardson.
I just wanted to make sure we did that before we did anything else.
All right, so it's inadvertence at this stage because everyone's on notice as to this Detective Wilson being a domestic violence detective and coming into contact with this link. The defense is not prejudiced.
Judge, we don't have to address it right now, but there was another witness that I deposed yesterday, which I believe what he would testify to is outside of the window of what you've already said was relevant as far as previous bad acts. So we can address that now or later. I want to put that on the record.
If I were to call him as a witness, it'd be for rebuttal, and we can address that at another time.
My understanding is the only thing that the state wants to go forward on today, the case in chief, is based on their motion for reconsideration of the jail call, right?
So we also are calling Detective Cruz, just kind of to piece the timeline together. His testimony shouldn't take too long.
All right. Anything else you want to put on the record other than what's in the written motion for reconsideration?
I'll let Ms. DeLeon handle that.
I read the motion, so there's anything in addition you want to put on the record?
Judge, good morning. ASA Jennifer on behalf of the state, and Judge, I have copies of the case law that I cited if the court needed printed copies. Judge, the only thing the state would want to supplement to this motion is that it's imperative, Judge, to allow this jail call, not only to show consciousness of guilt, Judge, but I think that it's essential for this jail call to prove also it goes to the elements of our crime, specifically, Judge, to the fact that this defendant lied to 911, Judge. She lied to responding officers. She lied to more than one officer that arrived on scene, acting like she didn't know what was going on, how he got shot, who shot him. It's imperative, Judge, to show as to the depraved mind element to our case in chief that she did this with that intent and depraved mind, because the jail call specifically says, had I known, basically, essentially, in the sum of it,
Had I known what?
how much, Judge, she said, 25, and Judge, I can play it for you so you can hear it word for
I
word.
accept the prop, had I known
So,
essentially what the offer would have been, I would have.
no, so she goes, Judge, it's specifically like this. She goes 25, 25,
25 means what?
25 years, Judge. 25, 25, I would have cut that motherfucker up, and I would have scattered him all over Florida. It's essentially what the call entails. She doesn't say, had I known, quote unquote, it's just a sum of what basically the state was saying. And it's an additional admission as well, Judge. That's what the state would like to supplement to its motion. And I think it's imperative, Judge, I understand you accept my proffer to the court. I think it's imperative that you hear the portion that the state wants to play so that Your Honor can hear the context of it as well.
I accept the proffer. Do you want to respond?
Judge, I think you conducted the proper legal analysis last week. You made your ruling. Nothing in the state's motion adds any light to that. There's no case law that supports their position. You've made your ruling. They've given you nothing to give you any reason to reverse your ruling, so I'd ask that you keep it.
Anything else you want to add?
Up to defense's argument, Judge,
This is the way it goes. You first, and second, and third. Anything else you want to add?
well, just to defense's final point that there's nothing in the case law that supports our position. On the contrary, the case law that I cited in the motions support our position.
The motion for reconsideration is denied. Statement's not coming in, / the alcohol, more prejudicial and probative. It also goes to a discussion on the breakdown of plea negotiations, as opposed to 3 years later, as opposed to what she was thinking at the time that the quote unquote trigger may have been pulled. All right, your objections are on the record. The next thing I have is, if they rest after cruise, what are you going to, how are you going to proceed today?
So, Ms. Link's mother and Ms. Link's son are actually here.
Oh, great.
I didn't know this until late last night. They were jumping on a flight. So I haven't seen them yet, but I believe they're right outside.
Okay.
So the mother, the son, her sister, and her cousin are there, so they're ready to testify.
David Perez?
David Perez, no. He's refused, so, and that's why I asked the court to compel his appearance.
What else do you need from me?
Well, Judge, he's not even a witness, and you don't have jurisdiction over him.
No, hold on. Before I rule on your motion to exclude him permanently, at some point they had contact with him in the last few days, right?
Yes.
After he ignored you, I excluded him without prejudice, you reestablished contact.
Right, so I took 2 depositions yesterday. The state had 7 for deposition yesterday. I had contact with him. He agreed to appear yesterday, and then the evening before, Sunday evening, he, without giving me any reason, he just said, I can't make it, sorry. And I advised him, you're on probation. I can ask the court to compel your attendance. I don't understand what you're doing. Just come, get it over with, and you'll be done. And he just said, do what you have to do, goodbye. And that was the last call.
He lives locally.
Yes. He's on probation in Miami-Dade County.
To the extent that we know he lives locally, because as I mentioned, I don't mean to interrupt, but as I mentioned about a week ago, 2 weeks ago, whatever it was, we attempted to take his deposition. At the time, he said he was at work, and I believe he was either in Fort Myers or Fort Pierce. He has a local address, but that does not mean that he lives locally.
He may be a traveling individual. The crux of his testimony is really for the incident that happened 5 days prior.
That is correct.
And you would corroborate the argument, the battery, as well as be able to authenticate the photographs of her injury.
Correct. And Mr. Jimenez attacked him as well.
Would any other witness here corroborate what David Perez would testify to?
Pedro Jr. can, and obviously Ms. Link can, she testified.
So
What about the mother?
The mother was not there when the pistol whipping incident happened. The mother was at the home a few hours before Mr. Jimenez died, and the mother did witness interactions between Mr. Jimenez and Ms. Link shortly before she left, which she left a couple of hours before the shooting, and she did witness Mr. Jimenez grab her and be aggressive and violent with her.
So I think we need to address Pedro Jr. is not a witness right now, and there are a number of different steps before we can even get him to be reestablished, and this court reconsiders whether or not he can testify. I have to take his deposition. If this court recalls, a few weeks ago, I got on a plane, I went to Dallas, I was at the location that we all agreed upon the deposition was going to be taken, and then Ms. Perez, the defendant's grandmother, this witness's quote-unquote witness, because he's actually been excluded at this point in time, refused to provide him for deposition. I still need to take his deposition, which will take a significant amount of time. The rules are pretty clear when it comes to child witnesses.
I looked at the rule 92.55. I was wrong, there's no per se exclusion.
No, but the court has to, they need to be deemed competent. So the court needs to have an inquiry whether or not this individual is
I couldn't
competent.
find it.
I don't know the rule offhand, but I'm proffering to the court as an officer of the court.
No, I brought it up and now I can't find it. So it has to do, I mean, I looked at the rule regarding testimony of witness under 18, but it really has to do with whether or not you all have noticed something in the witness. And then I can further in.
I don't know, because I've been unable to take this deposition of this quote-unquote witness because he's not even a witness here. I have literally been precluded by the defendant's family from inquiring from this potential witness, which then there is further investigation that needs to be done. There's a reason that depositions don't happen in the middle of the trial, right? It's because there's further investigation that needs to be done. There's further witnesses sometimes that need to be brought in and questioned. There's other photographs, videos, etc. of all these other things.
How long are they here?
I don't know. They just got here. I think they're here at least until this matter's over.
And we need to do that. Then the court needs to make a determination whether or not this person is competent to testify, which in the defendant's statement, she says that he's on medication. He has a behavioral disorder.
What other witnesses do you have here that might testify besides those two?
3 others.
So
Crystal, Laylene, Josefina.
did you depose any of them?
I took all 3 of their depositions, yes.
Okay.
And I think that, I know we're kind of doing different things at different times, but I think that the court is
I'm
going
just trying to
No,
not waste this jury's time, allow you to depose Pedro Jr., but the other 3 sounds like you've already deposed.
Right, but what I'm saying is I think for each of those witnesses, the court is going to have to give specific limiting instructions on what they're able to testify to based off the court's prior rulings.
Okay.
Because I don't want, I think that we are, based off deposition of at least one of the 3 of those witnesses, we are going to come very close to this one of the witnesses, and I'm speaking about Josefina Perez, blowing this entire trial off.
Who would you call after the proves?
Judge, I would call Crystal and Laylene. I'd like to have a little bit of time before I call Josefina, I have similar concerns, but I believe I can be under control, but I just would like an opportunity to speak to her for a few minutes.
And after Cruz testifies, if you can get in at least one of them before lunch, can you call?
Certainly.
Sure.
And I just bring them in after you rest, or you want me to talk to either Crystal or Lee?
I think that you should bring them in as they get called. And, the additional part of this is I have reason to believe, based off of the emails that were sent to Mr. Tomas forwarded them to both Your Honor and myself, that there has been violations of the rules of sequestration based off of the email that Josefina Perez sent to Mr. Tomas saying, I've spoken to Crystal, I've spoken to Leyland, I've attempted to speak to David to convince him to come and testify. I have concerns that they have been violating that rule, and that's further, corroborated by the fact that Crystal Barreto was actively trying to log in the Zoom during the trial, despite the fact that we had already invoked that rule. I think that there are issues here, and I think that the court needs to instruct them individually.
Okay, so why don't we do this? Can you bring in Ms. Perez so I can tell her not to leave jurisdiction?
Josefina Perez?
Yeah.
Yes.
Not to leave jurisdiction.
One moment.
With the child until I say she can. firearm driver.
Yes.
You told him you had some challenges getting here, but now that you're here, you cannot leave Miami-Dade County until I tell you to do so. I'm not the great and powerful Oz. I'm not trying to bring down the hammer on anyone. He's been working very hard to put together a defense. It would be unfair to him
No, I won't do that.
and your daughter. So I'm telling you, don't leave Miami-Dade County, and that's court order, okay?
Madam Honorable, I will be more than happy to stay. I won't do that. I just leave.
I'm gonna try to see if you all can't testify today. If that's not possible, then tomorrow, okay?
Very good.
But I don't anticipate me ordering you all, meaning you and Pedro Jr. to
Right.
stay here past tomorrow, okay?
Your Honor, but we can go outside and things like that, correct?
Oh,
we
yes,
can.
you can. If you recognize anyone that's a juror, they usually have a little card on them, ignore them.
Okay.
Please don't talk about the case
No, I won't.
in the
But
vicinity of anyone, just in case there's a witness lingering around that you don't that you don't recognize it. That sort of makes sense, right?
correct. And we just got here at 5, so I want to see if I can get him something to eat before he even comes in. He's so tired.
That's fine.
Okay.
You just stay in contact with Mr. Glass so that he knows where you are.
Yes, ma'am.
Because I think there's a possibility that either you or Lelaine.
So I'm probably gonna call Laylene and maybe Laylene and Crystal before we break for lunch, so I just need them to stay where they are. Oh yeah, take Pedro to eat something.
All right,
Yes,
thank you, Your Honor.
need something.
That's it?
Yeah, that's it.
Okay, thank you.
Okay, so you put on cruise, we take a little break, I bring in, we rest, right? And we take a little break.
Yeah, we
I bring
can do
in-
JOA.
And then we bring in Crystal and we handle it like that. All right, Umberto's telling me the jury's here. So, can we bring in
And,
Cruz?
yes, very good, we'll watch that. Yes.
All right, let's bring in Detective Cruz. I'm sorry, jury first.
And just does this real quick?
Yeah. Mr. Glass, the state gave me another statute to look at when you